Hi, everyone. Welcome to the Refugee Welcome Collective Lunch and Learn series. In these sessions, we aim to bring interesting and timely information to you, supporters of refugees. Whether you're a volunteer, community sponsor, resettlement agency staff, a local advocate, or just someone who's interested in learning more, we hope that you enjoyed today's session, Fair Housing, How to Advocate for Newcomers and Safeguard Against Discrimination. Refugee Welcome Collective collaborates with partners to provide in-depth training programs, weekly learning sessions, resources, and on-demand technical assistance for sponsors, practitioners at resettlement agencies, refugees paired with sponsors, community and institutional partners, and others to support quality community sponsorship programs across the United States. Go ahead to the housekeeping slide, please. Thank you. As a reminder for everyone joining the call today, there's a control panel in your upper right-hand corner that will allow you to submit questions through the questions box. Please do that through the questions box, not the chat. There will be ample time at the end of the webinar for Q&A. Everyone on today's webinar is automatically muted. However, if you have any tech issues, please raise your hand through the control panel or submit a question in the questions box so we can assist you. Additionally, the presentation, any resources, and a recording will be sent out to everyone following today's webinar, which brings us to our presenter for today. And our presenter is Lynette Pearl. She's the Senior Associate of Housing for Refugee Housing Solutions. Unfortunately, Lynette is having some technical issues. I know she's been working kind of behind the scenes with myself and with Grace, who's on the call, to try to log in. But unfortunately for right now, she's unable to do so. So I'm going to, she put together a presentation, and I'm familiar enough to be able to go through some of the presentation as we sort of wait for her to hopefully get logged in so that she can answer questions. But so we're going to go ahead and go through it. And her or maybe someone else at Refugee Housing Solutions might be able to log in, hopefully soon. But if not, I'll go ahead and go through the presentation and then we can talk about it. Go ahead and click that next. Yeah, there you go. You can keep going. Let's see. Okay, so today's learning objectives. What is the Fair Housing Act? Why is the Fair Housing Act important to refugees and newcomers? Who are federally protected classes under the Fair Housing Act? How to file a Fair Housing Act complaint, and then we'll do some Q&A at the end. I think Lynette may be logging in, so we'll wait just 1 second while perhaps her audio. Lynette, can you hear us? Lynette, there you go. I think. Excellent. Hi, Lynette. We can't hear you yet, but can you hear us? We can see you now, but can't hear you yet. I'm not sure if Lynette's able to hear us. No, yeah. I can see her, but can't hear. So I'm gonna go ahead and keep going here. Church World Service is a faith-based organization working to help communities around the globe with sustainable responses to hunger and poverty, displacement, and disaster. And Refugee Housing Solutions is the technical assistance, TA provider for through PRM, and it's through CWS. So, Lynette, are you able to hear and see us?
Hello.
We can. Yeah, we can hear you. Great.
I apologize.
That's
I don't
okay.
know what happened.
No, that's okay. We kind of got started just because I know you're having technical difficulties, but Grace, are we on the, yeah, are we on a good slide here? And then Lynette, can you take it from here?
Okay, I'm gonna get make sure I'm organized. Again, I apologize, Derek. How
You're
far did you get?
just to here. So I just talked about CWS, and now just talk about who you are at Refugee Housing Solutions.
Okay. Well, Refugee Housing Solutions, we were created to bring housing experts and property managers and key stakeholders and those working in the refugee resettlement place together to discuss best practices and innovative solutions that will increase housing opportunities for newcomers. Our funding does allow us to provide resources and training such as this and one-on-one technical assistance support. And we'll talk about that later in the webinar, how you can activate one-on-one TA if you need it to support not just the resettlement agencies and the affiliates, but we also provide TA for property managers, landlords, sponsors, and volunteers. Since collaboration and partnerships, they are vital to addressing this housing crisis. We have initiated a National Housing Working Group and a Regional Community of Practice. And the National Housing Working Group and Regional Community of Practice, they are stakeholders that share a space in order to talk about best practices and way to combat this housing crisis. So after this webinar, feel free to go to our website and see when the next Community of Practice and also when the next regional work group is happening. Next slide. First thing before we get started, I'm very excited because I'm very passionate about housing in general, but fair housing. I don't know if you guys are aware this is Fair Housing Month. So Derek was very strategic about having this training to make sure you as volunteers, as sponsor, have this information. So when you're working with a newcomer, how to help them navigate through the system, but also to make sure they know what their rights are. And also, hey, you might be a renter yourself. You need to know your rights so you can be your best advocate. So I want to say this before we're getting started. I have to state a disclaimer. This is just educational purposes and just a resource for you to use. This is not legal advice. If you do have some questions or you are working with a newcomer that is having some issues when it comes to fair housing, I recommend that you consult a lawyer, or if you have some questions you want to actually implement in your program, if you're resettlement staff members, consult with your legal team, your legal department. So I just want to put that disclaimer. Again, this is just a resource, and this is not substitute for any legal advice. Next slide. So Fair Housing Act of 1968. So a lot of people don't know, unless you're really into it. On April 1st, 1968, President Lyndon Johnson, he signed the Civil Rights Act, which was meant as a follow-up to the Civil Rights Act of 1964. The 1964 Act, it expanded on previous acts, and it prohibited discrimination concerning the sales, rental, and financing of housing based on race, religion, national origin, and sex. And later on, it has been amended. The enactment of the Federal Housing Act on April 11th, 1968, a lot of people don't know, it came only after a long and difficult journey, and that was from 1966 up to 1967. And Congress regularly considered the Fair Housing Bill, but failed to garner a strong enough majority of its passage. And this is what the life-changing event that got this going. When Dr. Martin Luther King was assassinated on April 4th, 1968, President Lyndon Johnson utilized this national strategy to urge the bill's speedy approval. So that's what launched the Fair Housing Act, is after Dr. Martin Luther King was assassinated. And a lot of people don't know, I'm from Chicago. He stayed in Chicago for him and his family for a couple of years to address the fair housing issues in the Chicago area. And a lot of people don't know that. So he was very active, not just in civil rights, but this is part of civil rights, but very active in the housing movement. So next slide. And can you hit it again? So I'm just gonna give a summary of the Fair Housing Act because it's so in depth, but I'm just gonna highlight the things that are very important. And again, like I stated, the main importance of the Fair Housing Act of 1968 is to prohibit discrimination practices based on a person's color, race, religion, sex, national origin, and familial status. Now, when I talk about the Fair Housing Act of 1968, I'm talking about the federal protections, because states do have protections within their state that have extended beyond the Fair Housing Act. So just FYI. So in this training, I'm just going to focus on the federal ones. And the importance of fair housing, it ensures that all members of protected classes are not discriminated against in housing transactions. Can you click it for me, please? Grace? So you asked who is protected. And again, I'm going to cover the 7 major classes that are protected. However, I urge you to look up any additional protections within your state. Of course, race, we're going to hit race, color, religion, national origin, which a lot of newcomers face that type of discrimination, gender, disability, and familial status as well. That's another thing I have found in my work in the resettlement space. Those 3 main areas, a lot of them face housing discrimination. Next slide. Next slide. I want to talk about this too, because I don't want to leave this on the table. Again, each state varies. I know I keep repeating it, but some people keep forgetting that there are additional protections in your state. The one thing I really want to highlight, especially, is the source of income. I get a lot of TA from a lot of volunteers, even sponsors. I met with a sponsor group last week stating we're trying to advocate for housing for a newcomer, but the thing we're falling into trouble is when a property manager is not taking their resettlement letter as a source of income. And that is something in some states they have highlighted, that regardless of if it's legal income, you cannot discriminate against a person based on their income. And we're going to talk about what law that is. Can you hit it for me, Grace, please? And that's called the Equal Credit Opportunity Act, and that would fall under that. It's unlawful for a housing provider to discriminate against an applicant if income derives for even public assistance. So this is a wide umbrella, but we're finding other things that are going to be going under this act. And source of income is one of them. And let's go ahead. You can, next slide. So we're going to talk about the disability protections. Next slide. And can you click that for me, Grace? Thank you. With the Federal Housing Act, it does prohibit housing providers from discriminating against people because of their disability or disability of anyone associated with that household and treating them unfavorably. The Act does define individuals with a disability to mean those with mental and or physical impairments that substantially limit one of their major life activities. And life activities can include caring for oneself and performing manual tasks. Can you click it for me, please, Grace? So I'm an example type of person, and I think when we're talking about fair housing, there's some overt ways that people are discriminated against. So I'm going to give you some examples under the disability one. For example, if a housing provider refuses to allow an emotional support or service animal, or if they charge a deposit for one. A lot of times people want, especially if it's a property that has no pet, it's a no pet zone, or that's not their policy. If this person under the Fair Housing Act has a disability, they have a support animal, they have to give them a reasonable accommodation for this. And we'll talk about reasonable accommodation right after this. But that is part of discrimination. If they're coming to a property state, look, I have an animal, can I let my animal live with me? And they said, well, this is a no animal zone. They said, well, I have a reasonable accommodation. They have to accommodate that. So let's talk about what a reasonable accommodation is. Can you click it for me, please, Grace? So with the reasonable accommodation is a protection, like I said, of the Fair Housing Act that gives people with disabilities the right to request a modification within reason. That's the key word, within reason, in rules, policy, practices, and services, and physical amenities. And who can request a reasonable accommodation? So an applicant can request a reasonable accommodation while they're doing their application. Like, for example, if they know that they have a service animal and they're about to apply to a property that does not allow animals, they can request in that application process for that reasonable accommodation. With a physical and mental impairment, if you have one, they can request it if you are currently a tenant. God forbid something has happened to you during your tenancy and you need a reasonable accommodation, you can go down to your housing provider and request one. And one of the biggest things people ask, if you can click, um, um, go back, I'm sorry, go back, Grace. Who pays for the reasonable accommodation? Under FHA, fair housing laws, accommodation is deemed reasonable. The housing provider is responsible for paying for the cost of the change. If it's an undue financial administrative burden as determined by specific circumstances and relevant decision-making authority. So if a person goes in and make a reasonable accommodation, and it's unreasonable according to the housing provider, there are ways to go around that. But again, when you're talking about making a modification to a unit, if it's going to be an undue hardship to the housing provider, they can deny it. But we'll talk a little bit about that. And I'm going to give some examples of what examples of what a reasonable accommodation you can ask for. Now, an example would be, say, for example, you currently live there, and you're on the second floor, and it's difficult for you to get up and down the stairs. You have some mobility challenges, or even just walking. If you don't have assigned parking, but you have to walk across the parking lot to get to your unit, and you have a physical impairment, you have a right to ask for a reasonable accommodation for a spot to be closer to your unit. Allowing a tenant to move to a ground floor unit due to mobility impairment. Again, say if you're a current tenant, you live on the third floor and you have some mobility issues, you have every right to ask for your landlord to transfer you, as long as a unit is available, transfer you to a unit on the below floor. Now, a lot of people don't know this. So if you are a current tenant and you need to move to a different floor, part of that reasonable accommodation, they have to pay for the move. And a lot of people don't know that. So if you have a documentation from a doctor stating that you need to move to a lower floor unit, and there's a unit available, your housing provider has to give you that, has to transfer you to the unit, but also they have to pay for the cost of the move. And a lot of people don't know that. Another thing is an example is adding grab bars in a bathroom. So allowing you to come in and out manually, or if you have to replace locks, door handles to make a certain adaptation to your physical limitation. Another thing is allowing a live-in aid. I do know if you have someone who's elderly or if they have a disability and they need some support to get their day-to-day activities done, they're allowed to actually have a person move in as a live-in aid. That's considered a reasonable accommodation. Now, I want to add this disclaimer. So if you do have an actual client that lives in subsidized housing, like public housing, or they have a housing choice voucher and they want an additional live-in aid to move in, of course, with that particular program, rent is based on income. If this person is a live-in aid, they cannot consider that person's income towards the rent because it's a reasonable accommodation. So just FYI, because a lot of people don't know these things unless you're in the housing. So if you're dealing with a newcomer and you feel like, well, I don't think it's a good idea for them to live by themselves. However, they might have a trusted friend or family member that can live with them. You need to have them request a live-in aid. They need to do a reasonable accommodation for that. Again, we talked about earlier, permitting a service animal in no pets buildings. Another thing that a lot of people don't know, if it's a service animal, even if they do allow animals or they don't, if it's a service animal, they cannot charge pet rent, or charge them a pet deposit. That is because it's under the reasonable accommodation. Next slide. So I'm going to jump to, we're going to jump to race and color. I just added those two together. And go ahead, Grace. I want to make sure I stay on task because I can go left field with this because I'm very passionate about it. But I want to make sure that you guys get all the information you need. Again, race and color are a protected class. When Congress passed the Fair Housing Act in 1968, one of its primary goals was to prohibit racial discrimination. That's what got the ball rolling. It is illegal for a housing provider to treat someone differently, differently because of their actual race, color, or perceived race. That has happened, and or color because the person is multiracial or in a relationship with someone of a different race. A housing provider may not discriminate against a current or prospective tenant because they do associate people associate with a different type of race. So let's go ahead and talk about some examples so you can see what an example of discrimination would be under these two protective classes. For example, a housing provider refused to rent to an applicant and suggests the person apply at a building with renters of the same racial background. I've seen actual property managers do that, and they don't even know they're breaking the fair housing law. They'll say, well, for example, I'll use me. When I started out, oh, you're single and you're African American. I think you would prefer living at such and such property because you have more single African American women there. I'm thinking, wait a minute, that breaks the fair housing law, and that's steering. I'm like, but a lot of them think they're like giving you assistance. They think they're making you feel more comfortable in your own environment, but it is breaking the fair housing law. A property manager cannot do it, even if they're thinking they're helping you out or they're trying to guide you to your community. That is against the law. If a housing provider refuses to rent to lighter versus darker skinned newcomers of the same ethnicity, that goes under the color. So you could have someone of, I'll use me, African American, I'm considered brown skin. If I go in to apply for a unit and they state, well, no, the unit's not available, but my sister, my younger sister, who is a fair skin, a lighter skinned person than me, she goes in and apply. And they say, oh, yeah, the unit's available for you. That's discrimination based on skin color. We are both African American, but guess what? We have two different skin tones. So we're going to talk about national origin. Go ahead and click. I know this is what you're probably really interested in as well, because this will affect your population. Again, it prohibits based on national origin. Such discrimination can be based either upon the country of an individual's birth or their perceived ancestors. Can you go ahead and click on that? And I'm going to talk about an example. Again, this is an example. If a housing provider refuses to rent to a newcomer based on perceived ethnicity or rents only to certain ethnicities. Another example would be, for example, one property I lived at in my younger years, I had noticed a pattern. I noticed a specific it was mostly people of a different country. I'm not going to say, but I noticed there was a pattern. And I had brought that up to the property manager because I'm in housing. She said, oh, yeah, I prefer to rent to that particular people from that particular country. I'm like, well, that breaks the fair housing law. But again, you will see that. Or the biggest thing is if a housing provider tells a tenant or an applicant, you must speak English when you're outside the apartment. Now, there's difference if they're asking for you to have an interpreter because there's no one present. However, if a person is applying for an apartment and there's a language barrier, they have to accommodate you. That would go under the reasonable accommodation. But they can't be discriminating if you come into the office and they ask you, well, I want you to speak, you cannot speak your language. That is discrimination. Now, it's different if it's a language barrier. However, they cannot tell you you can only speak English outside of your unit. So that would be actual discrimination. We're going to talk about religion. Go ahead, can you click that for me? Now, discrimination in religion includes applying different terms or conditions of housing or denying housing applications or steering people to a certain neighborhood or building because of their religion. Go ahead, can you go ahead and click that? So let's talk about the examples because it can help put it in perspective. So for example, if a housing provider refuses to rent to a newcomer or steer them from a property based on perceived religion, if they say, well, are you Muslim? If they ask you if you're Muslim, well, would you prefer to, there's like building A, we have a lot of Muslims that live in that building. Now that goes against the fair housing laws. Or they discourage you from putting decorations in a rental unit. You cannot do that. That goes against fair housing laws. Or the biggest thing I have found is if you get a lease violation because you're cooking a certain type of dish and you're getting the landlord is complaining about it, or they're saying they're getting complaints from other tenants. They cannot stop you from cooking a certain type of dish, even if there's some type of smell that might be offensive to others. That it goes against the fair housing laws. Now they can prevent you if it's a actual fire hazard. Now at one property I worked at, one particular dish did cause a fire hazard the way they cooked it. So we had every right to tell them it would be inappropriate for them to cook it, not because of their religion, but because it was a fire hazard. So next slide. We're going to talk about family status. With the Fair Housing Act, with some exceptions, it prohibits discrimination in housing against families with children under 18. In addition to prohibiting an outright denial of housing to families with children, the Act also prevents housing providers from imposing special requirements or conditions on tenants or applicants with children. Can you go ahead and click that so we can talk about some examples? One of them is if a housing provider refuses to rent to a household with children or designate a specific building or floor unit as child-free. Another thing, if they're trying to charge a higher rent or deposit because a newcomer has children or have a larger family. Now, there's a difference if they're charging a higher deposit due to lack of credit and rental history, but they cannot charge you a deposit, a larger deposit, just because you have children or you have a larger household. Next slide. You know what? Let's back this up. I want to back that up. I just remembered. One of the things with newcomers, not all, because I don't like to put everybody in a classification. One of the things a lot of staff and volunteers and sponsors have said that they have it's difficult to house large families. One thing that I want to put under that, you cannot discriminate against a person, a household, because they're a large family. Now, there's one thing you have to realize if you are trying to house a large family, what is the code enforcement rules? And what's the occupancy guidelines. So you want to make sure that you know those going in, especially if you're trying to house a big family. So if you're going in and they say, well, no, we cannot accommodate you, you can know if it's a legitimate code issue, the reason why they're saying no, or is because they're discriminating because it's a large family. So just FYI. Okay, I want to just add that disclaimer. So let's talk about sexual harassment and gender. This kind of falls, this particular category has expanded over time, which it should have. Originally, it was unlawful to discriminate in housing on the basis of sex. Can you go ahead and click that? Grace, thank you. In recent years, the department's focus in this area has been to challenge sexual harassment in housing, women particularly. Now that has changed. Those who are poor with limited housing options often had little recourse but to tolerate the humiliation. I have seen this myself where exchange sex for rent, that is a protected class as sexual harassment, and vice versa, not just women anymore. Harassment of any type of form, any type of request for a housing provider in exchange for sexual favors for rent, that is protected. They cannot evict you, threaten to evict you, and they cannot retaliate against you if you decline their sexual advances. Another thing that has been added to this law, which should have, it goes under the sex, unlawful discrimination based on the applicant's renter's sexual orientation or gender identification. Now, with this particular protection, again, depending on what state you're in, they have even further this with sexual orientation and gender identification of protections. Again, I really recommend that you go and look up your state protection laws outside of the federal protections and see if there's additional. So I do know this one has been added under the sex protection, federal protection as well. Next. So let's talk about examples. This does go under the sex, not renting to an applicant because they are pregnant or on maternity leave. That kind of is a twofold thing, because they say, well, how you have any income coming in? Well, I'm on maternity leave. You can't discriminate against me because I'm on maternity leave. You can't discriminate against me because of my income, as long as I meet your income guidelines to apply. Just because I'm on maternity leave, you cannot deny me. Not renting to an individual because of their sexual orientation. If you see two people of the same sex and they are a household, they cannot decline their application. Or if you have an actual current renter and they have a partner, you cannot evict them, because that goes against the fair housing laws. Eviction or threat of eviction if you decline sexual advances. So we talked about that. Next slide. So one thing a lot of newcomers do not know, and especially people who work directly with newcomers, such as yourself, resettlement staff, volunteers, and sponsors, they think they have no recourse, which they do. They think, well, I'm a newcomer, I have no rights, or even if they're undocumented, they still have rights under the fair housing law. So I just want to make sure we put that out there, because you have a lot of landlords taking advantage of people, especially if they're undocumented, thinking, well, they're not going, who they're going to tell or who they're going to complain to. They have no rights. Yes, they do. Under the fair housing laws, even if you're undocumented, you have rights. You have housing rights. So let's talk about, what do you do when your rights have been violated? You can file a complaint. You can file a complaint with HUD if you want to do it exactly with HUD within a year after the discrimination has occurred. Or you can file in federal court within 2 years after the discrimination occurs. So it depends on the time when it has happened. And a lot of people say, well, how do you prepare? Well, the thing is, document. You have to document meetings, document phone calls, keep detailed records about everything, especially if you're working with a newcomer. Sometimes that they're going to be afraid not to tell. Say, look, no, you have rights, but I need you to tell me everything that has happened, especially if you're going to help them with the documentation piece. Any type of paperwork they have received, make sure you collect that. Save copies of their application, their signed leases, deposits, rent payments, any documents that can prove that they have been discriminated against. Collect written statements. If there's people that has been there, even if it's family members that were with them, that is considered an eyewitness. Anybody who was in the vicinity that heard the discrimination or saw the discrimination, get their statements. Next, can you click that? And who can assist you? One thing you can do, you can go directly to HUD, but you can also go to your Department of Human Rights in your state. I think that would be an easier lift. And another department is contact the local fair housing agency. That's all they do. They provide training, but that's all they do. They do follow-ups on complaints. They'll take an intake on the individual, give the information, and then also the good thing when you're working with the local housing agency, they can connect you to an attorney. They have access to attorneys, and they actually can send out a secret shopper to see if it's truly going on. So that's a good thing when you're working with an actual local fair housing agency. So next. And so here is the information. If a person wants to go directly to HUD, you can call them and get the process started. Or again, Federal Housing Equal Opportunity. And you can contact your local fair housing partner agency. I say do that because they're passionate about it. You'll get quicker response, and they'll walk you through the process. This is all they do all day long. So I recommend, if you're working with a newcomer and there's some issues, contact your local fair housing partner agency. And even if you don't have any issues with anybody you are working with, still contact them anyway to be educated. Find out what events are going on so you can attend those events, so you can keep up on any changes in the housing laws, because they will have that information for you. Next. So we talked about what they can't do, but I want to talk about what housing providers can do, so you can be sure that, okay, that is acceptable, so you know the difference. Fair Housing Act, it does not guarantee an individual a right to housing they cannot afford. So if you have a landlord that's rejecting an application due to the fact of affordability, they have that right. That's not breaking the fair housing laws. If a housing provider, they have the right to set the rent at whatever market it will handle. That's their right. They can do that. That's not breaking the fair housing laws. They might be gouging you, but that's not breaking any fair housing laws. A housing provider, they must create and apply objective and non-discriminatory criteria in their application screening and their tenant treatment. So that's something that they have to do. Can you click for me, Grace? And this is what is considered best practices when you see it from a housing provider, is if they have to ask applicants the same questions. If you feel, if you're working with an actual newcomer and you feel that there's some discrimination going on, you could be a tester yourself. So when you're going with them and just kind of jot down the questions that they're asking them during the application process. And then say, for example, you have another client you work with, maybe a different ethnicity or something is different, a different sex, different gender. Go with them and see, are they saying the same things they said to my other client, to make sure everything is consistent. And then one thing they are responsible to make sure that all their staff have been educated on the fair housing laws. Ignorance is not a reason. So that's one thing they have to make sure all their staff is educated on the laws. So I want to talk about this is one of the frequently asked questions of HUD. And I know a lot of people fall into some barriers when they're trying to apply for housing because again, they don't have the traditional paperwork or the traditional income, or if they run a credit because they don't have a U.S. Rental history or credit. Can we forgo that? And this is HUD's response. Yes, landlords and property managers may generally forgo credit checks for any potential resident as long as they do not discriminate because of a protected characteristics of the Fair Housing Act. So sometimes you will find landlords are actually discriminating against a newcomer because they don't have that traditional paperwork. Doesn't mean they don't have paperwork to prove who they are, paperwork to prove the proof of income. It's just they have alternative documentation. So sometimes they are doing reverse discrimination where they don't accept their alternative documentation. So I just want to make sure that I highlight this is what HUD has said. And this is under Operation Allies, and I know that it is geared towards Afghan refugees and parolees. However, we're talking about HUD. So this had rolled out during that time period of Operation Allies. However, it's going to transfer to other populations as well, because again, this is fair housing. So how can you say one population can have this, but another population can't? And so we're just waiting for the actual physical change. So this kind of wraps up our webinar. I know Derek is going to open it up for questions. However, if your questions do not get answered in this webinar, you feel free to email me at lpearl@cwsglobal.org, or you can actually book a one-on-one session. We do hold TAs on Mondays and Wednesdays. They're 30-minute sessions, and I can address any concerns or questions you may have. So I'm going to open it up to you, Derek.
Thank you, Lynette. Yeah, we're going to begin answering questions submitted during today's presentation. As a reminder, you can still submit questions through the questions panes in your attendee control panel. And I don't see any questions just yet, but we do have a couple of minutes, so please feel free to write them in right now. But I actually do have a follow-up question for you, Lynette. And thank you again, and sorry about the technical difficulties.
Yeah, I think it was on this end. So I want to say it was operator error.
No worries at all. Thank you so much for coming and for your great informative presentation. So some follow-ups. You had mentioned, if someone suspects that a landlord, an apartment complex or something potentially is discriminating against their clients or anyone, for one of those protected classes. Perhaps it's family, family number, familial dynamics, whether it's country of origin or race or ethnicity or gender. So you said they can make a complaint to HUD or to
The Fair
that, and
Housing
then
Agency.
you also they could reach out to their local, fair housing organization. And so, is it correct to say that it might not be a quick resolution? It might take a long time, but yeah. Can you kind of talk a little bit about that? Are they going to get heard right away? Is something going to change right away, or is this a longer process and that they probably in the short term, need to look elsewhere, but that they should still make the complaint or something like that? What's your recommendation?
It depends on the situation, case by case. Usually when it's an application process, you see discrimination going on during the application process. I say contact your local housing fair housing agency. And the reason why, they're probably under their radar anyway. Chances are they're under, but you have to get the process starting. They're under their radar anyway, and they're very depending on the size of the city. Smaller cities, they're very active, very aggressive when they're doing their follow-up when they get that complaint. I'm from Chicago, and when you contact a fair housing agency, they're depending on the level of the discrimination, they will act quickly. Especially now, they're very sensitive to when it comes to newcomers, resettlement newcomers. They respond very quickly. Now, again, HUD, that's a different thing when you're calling HUD. You're talking about a federal agency versus when someone who's already grassroots on the ground, they already know what's going on in their community, they're going to respond a little bit quicker. Sometimes people think, well, it's not worth it, but you still got to get that ball rolling.
Yeah, thank you very much for clarifying that. We do have a couple of questions that came in, so
okay.
We'll get to that. First person said hello and said, can you specify the law for renting to people who do not speak English? Is that grounds for discrimination if a landlord refuses to rent based on this? So based on
you cannot.
Great.
You cannot discriminate against a person because they cannot speak English. In fact, they have to accommodate that person. That would be under a reasonable accommodation. One of the things I talk about, they would have to allow them to have an interpreter if they allow them to have a trusted family member, friend, sponsor, or volunteer to interpret in their behalf. They have to. Now, I want to add this as well. If you're having a client that's applying for public housing or any type of property that's receiving federal funding, it's mandatory that they even provide a person to translate.
Thank you. So that's the Fair Housing
That's under Fair Housing. Yes, it's the Fair Housing Act. Yes, you cannot discriminate.
Specifically under country of origin or perceived country of origin.
National. That would fall under national origin. Yes.
Yeah. Great. Thank you very much. Someone else is asking about what are the laws around limiting the number of people who can live in a single unit? And I think you had mentioned, occupancy laws, and that those can vary per state and per city or location.
And locally as well. So you can be in the same city and have different local ordinances. So that's why I said check with your local ordinance and your state ordinance just to cover it. The best bet is to contact your public housing authority in your area because they will have those occupancy limitations because they are required to have it to be in compliance with HUD.
Thank you very much. One more here. Thinking about a family who has several children. Okay, number of they were talking about the number of people. So if they're prevented or what laws to understand. So you're saying it's the occupancy laws or ordinances that govern, and that can be like by city, it can be by areas of the city or what have you. So whoever, and your recommendation is to reach out to the public housing organization in town because they'll know what those regulations.
They would know that they have to know the guidelines because they have to abide by them for their public housing. And if you don't have a local housing authority, you can even contact your code enforcement they would have those actual occupancy guidelines.
Great. And I think that's it. But Lynette, I just wanted to say thank you again for presenting today and for the informative and thoughtful responses. And thank you to everyone for listening and for attending today's RWC Lunch and Learn. There is a QR code right here that you can take a survey. Tell us, what you like and what's been, how we can improve our Lunch and Learn series. You can let us know if there are any particular topics or speakers that you would love to hear from. This is your opportunity to give us some feedback, and we really appreciate that. I think Grace also put that in the chat, a direct link. So we really appreciate you taking the time to do that. And just wanted to say thank you again to Lynette Pearl of Refugee Housing Solutions for presenting today, and thank you to everyone. You will receive a follow-up email with a link to view the recording of today's webinar. And on behalf of Refugee Welcome Collective, thank you for joining us, and I hope you have a great rest of your day.